Welcome to the Appellate Division, First Department. We have 7 hours of argument time requested, so I'd ask that you only ask for the time that you need, not the time that you desire. We are familiar with the briefs and the records, and if we have more questions, we will keep asking them, even if the time is up. People versus Chambers, submitted. Burvis versus Burvis, submitted. Jasmine versus Albert. Appellant. Respondent for the mother. And okay, 5, 5, and 5. People versus White. Appellant. Respondent. 5 and 1 and 5. Solomon versus Amazon. Do you wish to argue since the appellant is not here? Okay, wise choice. Oh wait, are you the appellant?
5 minutes for rebuttal, please. 10 minutes.
I'm sorry, you're the appellant?
I'm the appellant.
Okay, do you want time then since he is here?
No, I'll just answer any questions that you.
Okay, so I'll give you each. I'm going to give you each 4 minutes. You don't have to use the 4 minutes. If you don't have any questions, we don't have any questions, you can just, okay. Cunningham versus City of New York, appellant. I'm sorry, what?
With all due respect, I'll ask for 15 minutes.
You can ask for that.
Labor law thing, I have like 4 minutes.
Okay. There's 4 parties though, so if we gave everyone 15 minutes, we'd be here all day just on your case. So, but okay, go ahead. Okay. And there are 3 respondents, so.
City of New York requests 5 minutes, please.
Okay.
Clear out for 5 minutes.
And the,
TCO requests 5.
okay, 5 and 1, 5, 5, and 5. And again, if we have more questions or we need to ask for more points, we'll give you more time. People versus Gully is submitted. Williams versus McAlpine, appellant.
Appellant responding, 4 vote, please.
You're the appellant respondent.
Yes.
Is there an appellant here?
He's not coming, he has the flu. He put in, I believe, letter of unavailability an hour ago.
Okay, I didn't see it, and it didn't get to me.
Yes.
Okay, so you're, how much time are you requesting?
Just 4.
And how much time are you requesting? Okay, 4, 1, and 3. Swazo versus 501 Madison, appellant.
Requesting 5 minutes. Responding, Your Honor, requests 5 minutes, please.
Okay, 5 and 5. Cruz versus Angamarka, appellant.
Appellant, 4 and 2, please.
Respondent? I'm sorry, what'd you say? 4, 2, and 5. People versus Stokes, appellant. Respondent? 6, 1, and 6. Ostrager versus Chaffetz, appellant. Respondent?
Responding, 5 minutes.
5, 1, and 5. Endurance American versus StoneX Commodity, appellant.
Appellant, Your Honor, requesting 8 and 2.
Respondent? 6, 1, and 6. City of New York versus Jones. Okay, the city's not here. Submitted. Upfront Megatainment versus Theom, appellant. I'm sorry, what'd you say, 3 and 2? Respondent? 3, 2, and 3. Maria Appellant, submitted. Rivera versus New York City Department of Transportation, appellant? 4 and 2, please. Respondent? 4, 2, and 4. And Martino versus Chanel Capital is submitted, and Jacobs versus Sokoloff is submitted. So our first case today will be Jasmine versus Albert. That's frustrating.
Okay. Good afternoon, Your Honors. Cindy Brown for the appellants. May it please the court. It's well established, Your Honors, that the standard for determining change of custody or relocation is guided by the principle of the child's best interests, with the courts weighing the totality of the circumstances. For relocation cases, courts specifically consider whether the move will enhance the child's life economically, emotionally, and educationally.
Counsel, let me ask you, the court specifically noted here that it was making its determination based on the demeanor and the credibility of the witnesses. Since we don't have the benefit of that here and just have a cold appellate record, why should we revisit what it is that the court decided in this case, which was a fact-intensive determination based on the credibility of the witnesses and the demeanor of the witnesses?
Well, Your Honor, it's our position that the court made faulty credibility determinations. The vast majority of the court's assertions or conclusions were not supported by the record, okay?
So to be clear, we're not just bound by credibility issues, right? There has to be some kind of substantial basis in the record.
That's correct, Your Honor.
And in this particular record, the mother, because it was her petition, right?
There were cross petitions.
But she started
Yes,
the petition, right? And so she had a certain burden that she would need to meet.
that is correct, Your Honor.
And how did she not meet that burden?
Your Honor, she did not meet that burden because she did not show, for one, that the child's life would be enhanced educationally. The record shows that the mother had not done the necessary research to see whether or not.
For example, this child has an IEP here in New York State, and in Florida. Was there any proof in the record other than her testimony that he would be subject to the same IEP or something equivalent?
There was not, Your Honor. There was nothing.
Now, your client was also advised that it would be sensible to have the child be in therapy, but your client never arranged to have him put in therapy of any kind, correct?
Well, Your Honor, the child was already in therapy in school. After that one incident that happened in school, the school did suggest that perhaps maybe he should do family therapy.
And the father did not arrange that, correct?
He considered it, but ultimately he never enrolled the child in family therapy. That's correct.
Counsel, with respect to the IEP, you said in your reply brief, I think, that the IEP has been suspended in New York too, correct?
Well, it was decided at the end of the term between the family and the providers that the child no longer needed it. And I think that goes to that attests to the progress that the child made while living with dad. You know, the entire time the child's had the IEP for over 3 years, and in just 16 months of living with the father, his behavior had improved so much that everyone agreed that he no longer needed the IEP. And that just goes to support the dad's contention that the child really does do well while he's in the father's care. That was the same when he lived with the father for the 1 month when the child was 2 years old. The teacher stated that the child had improved. Notwithstanding that fact, the mom demanded that the child be returned to her. And now again, most recently, the child lived with dad for 16 months, and he did so well that he no longer
Back to
needed
the
it.
original question, why the court was wrong in its determination or abuse of its determination in finding that the child should be relocated, should be allowed to relocate with the mom?
The court was wrong, Your Honor, because the decision is not supported by the record. It's not at all. Mom did not prove that the child's life would be enhanced emotionally, educationally, or that the move was economically necessary. I think what the record shows is that mom met someone, she fell in love, she got married, and she wanted to move to Florida.
And in fact, after she got married, she left and went to Florida. And left her son here with the father.
That is correct, Your Honor.
And when the son was here with the father, the record would support the fact that if there was an issue at the school, the mother was still in Florida. She did not come back.
She did not.
Okay.
She did not, Your Honor. So, like I said, Your Honor, the court's decision to allow the respondent to relocate to Florida failed to account for the detriment.
What about, there was a finding in, after the hearing that the child was traveling like over an hour a day, I think, almost each way to get to school. That was, and therefore wasn't able to participate in extracurricular activities after school and to make friends. And that was an important point that the court made. Why would that not be an important point to consider?
Well, Your Honor, the child did travel an hour, maybe 20 minutes to school every day. But the reason why the father kept the
back,
child
of course.
enrolled in the same school was because he wanted to ensure continuity. He knew that his child benefited from routine. And given the fact that the parties were in court on this relocation matter, he didn't want to take the child out of school and move him and possibly have him have to move again once a decision is made. So it made sense.
But the record also showed that the father didn't make opportunities for the child to socialize with other children on the weekends or anything like that, correct?
I wouldn't agree with that, Your Honor, because the child was enrolled in basketball camp. The record shows that the child did basketball on Saturdays, and there were other activities that he did. So he did have friends from basketball.
He didn't make any arrangements for play dates or for the child to spend unstructured time with other children, right?
There were no play dates, no.
Thank you. Thank you.
Thank you.
You can move that mic down if that would help you. I have that problem all the time.
Okay, thank you very much. May I begin? Monica Eskin, appearing on behalf of the respondent mother, Jasmine Myers. May it please the court.
What about the argument that really this was just because the mother met someone and wanted to live in Florida, and there was really no compelling reason why it was in the best interest of the child to be relocated?
Yes, I understand what Your Honor is asking. Specifically, my client did meet someone, and eventually they got engaged, and eventually they did get married, and he did reside in Florida. However, before she went to Florida, before she made the determination that she was going to live in Florida, she went to Florida, made sure it was an appropriate place for her son. She did call the school and see if the school would offer the same programs that he...
Was there anything in the record that would support that other than her testimony?
In her testimony, no, Your Honor.
Okay.
That was received in evidence by the court, correct?
Excuse me?
Her testimony was accepted as adequate by the court.
Absolutely it was, yes, Your Honor. So yes, so she did make the arrangements to make sure that he would have the same educational opportunities in Florida that he had in New York. However, you know, it was a big picture thing. She did get remarried. She did fall in love. She did want to start a new family, a new relationship.
Well, I
with
mean,
her husband.
I don't doubt that the record would reflect that it was in her best interest to
Yes.
move to Florida, but we're here about the best interest of the child.
I understand that, Judge, but I'm also saying I do want to concede the fact that that was happening, but she did feel that in the big picture it would be in the best interest for her son. Her son was not doing well in New York, in the New York City school. As the myriad of documents show, he was having severe behavioral issues that had amplified, in fact, amplified while he was residing with
What
his
about
father.
the point that opposing counsel made about the IEP being lifted and that being a vindication of the father's parenting?
Well, respectfully, I don't think that is a vindication of the father's parenting. The IEP was lifted, and instead, at 504 modification was put into effect, which basically gave him the same things that he got through his IEP, which was small groups and counseling if he needed it. So,
How would we know
yeah.
from this record that when he went to Florida, let's assume that the IEP was still in place, that it would be equivalent services, because that is what would be in the best interest of the child, right? If the child has an IEP, one would want that to continue. And what do we have other than I called a school and they told me it's all good? What else? What do we have besides that?
Well, I mean, an IEP is a federal program, and it's accepted by all states and all states. So,
Do we have a letter from the school maybe that says that
No,
we would be
we do not.
considering and accepting the IEP?
no, we only had my client's testimony that she called. They said, of course, we would accept an IEP, and based on that, she felt that it was appropriate.
So I understand that one of the things the school had recommended is that the child get counseling in addition to that offered by the school, which the father did not arrange.
That is
Were
correct.
there other things that the school directed him to, or suggested to him to do that he did not do?
That I do not know specifically, Your Honor, as to whether or not he had been required to, asked to do other services for the child that he didn't do. I know in the past, my client had looked into services for the child through Bellevue Hospital, and she had asked him to attempt to assist her with that, and he refused to provide her any assistance with that. So based upon the testimony that was provided, it's my position that the decision of the court should not be overturned. The referee had the opportunity to, as the trier of fact, to determine in her capacity to determine the observations and credibility of the parties.
But we need, I mean, credibility, yes, is very important, and we do
Yes.
afford the family court certain deference in that regards. But there has to be substantial basis in the record, right? I mean, we are dealing with the law here.
Yes, are you saying substantial basis for the move or substantial basis for
The best interest of the
the
child.
best interest of the child? I mean, one of the
That's her burden to meet.
Agreed. And what I think one of the most important things to note in this case, Your Honor, is that the only way that this child would be able to have a relationship with both of his parents is if his mother had physical custody of him.
And why is that?
Because his father made no attempt to try to co-parent and in fact put my client in a lesser position than him. Throughout his testimony, throughout the documentation that was provided, he's never in any way tried to talk with her about their child's needs. When she's made suggestions to him about the child going to therapy, he turned it back on her and said she's the one that needed therapy. When she tried to talk to him about the therapy that was requested by the school, he refused to talk to her. She said, if anything comes up, please let me know. He said, I don't need to let you know because you're not important. This is the way it, okay, thank you, Your Honor.
Finish your sentence.
Okay. This has been the habit of the father towards the mother, and I truly believe that without the mother having custody, the relationship between the child and the father and the mother would suffer.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, the Children's Law Center by Laura Selecki, attorney for the child, who will be 11 years old next month. In this case, the family court made numerous errors which
Can I ask you something?
compounded.
Was your original position in favor of the mother and you changed once the child changed his position about what he wanted?
That's correct, Your Honor. When the attorney representing the child at the family court first met with our client, which was in May 2023, at the beginning of the trial, he supported the relocation. That was his position through the end of the trial, which ended in, I believe the in-camera was in August 2023. So over that period of approximately 5 months or so, he was consistent in that position. Once the decision was entered and the attorney met with him, November 2023, he had changed his mind and wanted to remain here with his father in New York, where he had lived for his whole life.
He's now in Florida as of, what did he go after the holidays in December of 2023, so he started in 2024?
Exactly, Your Honor. So the parties arranged for that transition. So I have spoken with him in October while he was with the mother in Florida. His position was the same. He wants to return. I spoke with him earlier this week. At home with the mother in Florida, obviously privately, his position remains the same, that he wants to return. He's insistent that neither parent has told him what to say to me or to anyone else about his position. So
Do
frankly,
you know how often has been since he's been in Florida, how often he's been able to see the father?
I believe
Because I know there was liberal visitation time. I'm wondering if they were taking advantage of that.
there is a schedule, and I believe it's approximately 5 times over the year. Obviously, the summer is a more substantial period. And they are arranging those visits. The mother is facilitating that. But I do want to point out, as counsel stated, counsel for the respondent mother stated that if the father had custody, this mother would not have a relationship with the child. That's simply not true.
Wasn't there testimony that the child spoke to the mother daily via Skype when he was here and the mother was in Florida?
Yes. Yes, and
Okay.
this is a good example of why I believe the credibility findings were faulty in this case. Both parties had testimony that, in a lot of ways, were very consistent with one another, and the court even made findings against the father that were inconsistent with what the mother's testimony was. So the mother testified. In the beginning, it was rocky, the phone calls. They were short. Dad was cutting them off somewhat, but it got better, and she spoke with him daily. This is not a father who's completely cutting off all contact between the mother and this child. They were speaking every day. So really the many findings that, as I pointed out in my brief, that cast the father as an inferior parent, that was something that the attorney for the child, in summation at the end of the hearing, never even argued that the father was inferior. It was really just sort of the mother's conclusions about why Florida was a better environment.
The mother's counsel recounted to us several examples of statements made by the father that suggested he denigrated the mother and did not think highly of her. Do you agree that those statements are in the record?
There are several statements like that, and the mother also agreed that the insults and the hostility ran both ways. The court completely ignored that the mother was candid in that regard. The father was candid about that. But these are two parents who went to every single IEP meeting together. They went to every parent-teacher conference together. They didn't always get along, but both of them were involved the entire way. And the court discounted the father's involvement in the education entirely based on his hesitation when the child was in pre-K, his initial hesitation about the IEP process and what stigma it might have on him. And after that, the father agreed with all the services.
Except that he never arranged therapy for the child, correct, outside the school?
He did not arrange that outside family therapy. That's correct.
Thank you very much.
Thank you, Your Honors.
People versus White.
Your Honors, with the leave of court, my colleague Peter McGinley will argue you've granted his pro hoc vice motion.
Thank you.
Thank you.
Good afternoon, Your Honor. May it please the court. Pete McGinley of Deckert LLP on behalf of the appellant, Deshaun White. We think there were two reversible errors in this case, Your Honor. First, we believe that the jury's verdict was against the weight of the evidence. And second, we think that the trial...
Sorry, People v. Peterson is something you have to grapple with, obviously.
Yes, Your Honor.
Doesn't that foreclose that first argument?
I don't think it forecloses it, Your Honor. We think that Mr. White's appeal is substantially different from Mr. Peterson's, despite the fact that they were co-defendants. We present different issues. We present additional arguments and authorities on each of the points here on appeal. So if you begin with on the weight of the evidence, if you look at intent.
Can we agree that intent is formed at the time of the taking and not necessarily any thereafter?
Yes, Your Honor, intent is formed at the moment of the taking, but this court has said in Ray Carleek P that the court has to, or the jury has to look at all of the circumstances surrounding the conduct, including events before and after. We think that here, Mr. White's conduct, when viewed in that lens, reveals that there was no intent. We have him approaching a sleeping passenger, moving a backpack a few feet away, looking,
rummaging through it.
Rummaging through the backpack, yes, Your Honor. Taking nothing and voluntarily leaving. There was no intervention. There was no suspicion that he was going to get caught. He voluntarily left.
But at the time of the taking, right, if they had just moved the backpack, okay, maybe I want to get a seat, it's in the way, whatever.
Sure.
But then the rummaging through it, doesn't that lend to more so that there was a larcenous intent?
With respect, Your Honor, I don't think so. And the reason why is because if you compare it to cases where this court has found intent there's just none of the additional factors. I understand he rummaged through it, but he took nothing. If he intended to take something from the bag,
Doesn't that just mean that he didn't find anything that he wished to take? I mean, normally you don't rummage through other people's backpacks when you take them from them.
that is true, Your Honor.
The fact that he didn't take anything, isn't that just more indicative that there was nothing that he wanted to take?
That may be so, Your Honor. We don't think, if you compare it to the cases in this court that have found intent, that rummaging through it on its own is indicative. But even if you believe that there was intent to steal something, this is why, in part, we also argue that the trial court erred in refusing to instruct the jury on attempt. Because if you look at, for example, the Moran case in this court, the defendant in that case reached into a complainant's pocket. The court said there was clear intent there, reaching into the pocket, to steal something.
But wasn't the completed act in this case the fact that they took the backpack away from the person and took possession of it? Wasn't that a completed larceny at that point? So how can there be a lesser included offense charged of attempt?
Sure, Your Honor. Well, so I would point the court to two cases where there was conduct similar to here. I don't concede that there was a taking per se, but there was conduct similar to here. If you look at In Re Pierre B, in that case, a student on a bus grabs another student's backpack, grabs it away from them, rummages through it, and it's only when the other student takes it back that the student relinquishes the backpack. The court in that case said very clearly, if this conduct was done by an adult, it would have constituted attempted fourth-degree grand larceny. If you look at in the Peterson opinion, the court cites the Olivo case for the position that there was a completed larceny. But if you look at Olivo, one, we think that the facts in that case more clearly establish that there was a completed larceny. That's a case sort of classic shoplifter, takes items off the shelf, hides them underneath his clothing, bypasses the cash register, and attempts to leave. And it's only when he is attempting to leave and is stopped does he's stopped and he doesn't actually get away with the property. We think those facts are more clearly indicative of a completed larceny. But if you read the opinion in Olivo, the court actually says that the trial court instructed the jury in that case on attempt. And so if an attempt instruction in Olivo was appropriate, we certainly think that it would have been appropriate in this case. So if I just may, just for a second, just the other point that we raise on the attempt point that is different than the Peterson case, we also raise an additional form of relief that Mr. Peterson didn't raise, that if the court were so inclined, it could, under CPL 470.15, downgrade the conviction if it weren't to completely vacate and order a new trial. But that's just another distinction between this appeal and Mr. Peterson's.
Thank you.
Yeah, thank you.
Good afternoon, and may it please the court, Juliana Susu for the people. The evidence at trial fully supported the larcenous intent and taking element of fourth-degree grand larceny. As this court correctly found in co-defendant Peterson's appeal, the jury could reasonably infer from the defendant's conduct in taking the backpack, open it from the sleeping passenger, opening it up, rummaging through it, taking things out of the backpack, that the defendant had the larcenous intent to permanently deprive the victim of his property. Just because he later abandoned that scheme when he found nothing of value that he wanted to take with him doesn't mean that at the time of the taking he didn't have that larcenous intent. Likewise, the evidence fully supported the taking element. When the defendant took the backpack from the sleeping passenger, he exercised dominion and control over the backpack, even though temporarily, that's allowed.
The backpack was draped over the victim's knees, right?
Exactly, and the victim also testified that he gave no one permission to take his backpack. He was sleeping, so he couldn't give anyone permission. So it was in a manner wholly inconsistent with his ownership rights. Because there was a complete taking in this case, the evidence, there is, as this court decided in the Peterson appeal, there is no reasonable view of the evidence that he committed attempted fourth-degree grand larceny and not the completed. Again, although the taking was brief in this case, it was completed. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just one point in rebuttal, Your Honor. My friend on the other side mentioned the fact that the taking was brief and that a brief taking may still be a completed taking. But I would just like to point out for the court that invariably in this court's jurisprudence, where the court references a brief taking that is later abandoned, those are almost always cases where the defendant's attempt to escape with property or to actually take property is thwarted in some way. We note that here.
That's not a required element. That's just a fact that you see in some of the other cases.
Sure, Your Honor. That's correct. But again, when you're looking at both intent and a taking, we're looking at several factors here, and we think that when you consider them in their totality, it's clear that Mr. White both did not have the intent and did not complete the actual taking in this case.
Thank you very much for your pro bono service in this case. Solomon versus Amazon, and Justice Moulton is recused in this matter. Go ahead. You should go up, yeah, you go up and start talking. Go ahead.
I was going to read the inadmissible hearsay in the two emails that are the reason for this case, but I can't do it. If anything like that would have ever happened in a supermarket over an extended period, police would have been there in seconds. Anyway, there are 4 points I'd like to cover. The reason that we're here today also is because the court just didn't like. It's been going on for 8 years. I don't even know how many courts, at least 4, 5, 6 courts. The first 2 judges told me flat out, said, we're going to dismiss this case no matter what the pleadings say. That's at 128, paragraphs 47 and 48. All the courts, the only defense Amazon raised to inadmissible hearsay was I said it ad nauseum. There's no supported coherent argument in opposition to that. In the 8 years this case has been pending, not one court has said one word about inadmissible hearsay. I said that a lot in my brief, but I didn't cite the case of Denson versus Donald Trump. It's 530 Fed Sup 3rd, 412, 2021, New York Supreme Court. What happened in that case was when a court did not address the issue that the plaintiff raised, and it actually was this first department. It was a New York state court, and it was a case that came from this first department. And this first department didn't address the issue. And the court held that because this court didn't address the issue that the plaintiff raised, that raised judicata and collateral estoppel, and the plaintiff is free to refile as many times as it takes for a court to address the issue. So what I'm asking is for this court to be the first court in 8 years to say something about the fact this is inadmissible hearsay from people that didn't exist. My second issue that I'd like to talk about is conspiracy. You're not allowed to have new arguments in an answer brief. That's prohibited, and this court is prohibited from considering that argument. But Amazon raised conspiracy in one line of their answer brief, and I omitted. I didn't see that. I asked for a motion to address it so I wouldn't have to use up most of my oral argument time to address it. But this court is not permitted to address that. But if it does, Amazon said their objection was there was no agreement among the Amazon defendants. And that's not what I have to prove. What happened here was the 2 women made an agreement among themselves to have a conspiracy, and Amazon joined the conspiracy. So 2 points are, if this court does consider conspiracy, which is not allowed to do, Amazon waived any pleading defects by not objecting until the answer. And if this court wants to consider it, it's a minor pleading defect that Amazon didn't even plead correctly in their answer. I motion here for leave to amend my complaint to correct any minor pleading defect. The other points you're familiar with, although maybe not this, in my complaint, I've been with this for 8 years, so a lot of time. Anyway, my complaint cited Consolidated Edison, but none of the courts in the 8 years managed to see that the facts that I put there were for Richardson. So, of course, what that means is that, the trial court dismissed for failure to state a cause of action.
Time's up.
I'm sorry.
Your time's up, but we have your brief, so we will look at them. Thank you. Do you wish to respond?
No, Your Honor, I'm here to answer any questions you may have.
I don't think we have any questions.
Okay, thank you very much.
Thank you so much. Thank you. Cunningham versus City of New York.
Good afternoon. If it please the court, Mark Cambereri from Sobo and Sobo on behalf of plaintiff appellant Timothy Cunningham. This is a labor law action, arises from the Tube Street repair work, which took place over the entire second and, it took part in most of these.
Can I ask you a question?
Yes.
To start out with, we have a Court of Appeals case in Martinez that talks about also an asbestos abatement person who goes in before the main construction starts taking place and does some work and brings a labor law case, and the Court of Appeals finds that that is not an appropriate, that the plaintiff was not engaged in the type of work that 240 subsection 1 was supposed to cover. I wonder if you can address that. I know there have been other cases. I know about the Pratt's case from the Court of Appeals. I know about the McNeil case from our court, which seems to be a little bit different. Can you talk about that issue?
Yes. My legal analysis is that there's like 3 points with a investigatory inspection. So meaning that no work has been done, what they're saying, we'll assume that they're saying they're correct. There's been no work done. They're doing an investigation for asbestos. So there's like 3 points. That's the one. The second point is whether there was ongoing repairs and construction. And that doesn't mean that means that the person that's involved will be involved in ongoing work on this.
I'm having a little trouble understanding your answer exactly. Martinez, which my colleague mentioned, seems very, very, very similar to this case. The facts seem extremely similar in terms of it was someone who was doing work to determine whether asbestos was present prior to the project even beginning, and the court held that that was not activity protected by the labor law 240. How is that case distinguishable from this case, since there seems to be no real dispute that this work was done prior to any of the other work starting or beginning? It was pre-investigatory work. Why then is it covered by the labor law, and why isn't Martinez? Give your best argument as to why Martinez is not controlled.
Martinez doesn't apply because in Martinez, the fellow was just going to do an asbestos, and that was the beginning and the end of his work. There was wasn't going to be.
Wasn't that also true of the plaintiff in this case, that he was going in to do pre-investigation work as to whether or not there was any asbestos that needed to be treated, and that was the end of his work on this project? He was not part of the construction team who was going to go in and do any asbestos abatement or any other work on this particular project.
Okay. The asbestos in Martinez was like, if it was positive, then they would debate it. Right. If it was negative, there would be nothing to do. They would just go back to school, because that's where he was working in some school. Whereas here, this was this long, ongoing construction project to rehabilitate.
Counsel, did they know that there would be asbestos in this manhole, number 35, or whatever it was? Did they know that?
No, they were going to inspect every
Mr. Cunningham's job was to find out if it was there, right?
Correct.
And Mr. Cunningham was not going to be doing the remediation, if necessary, himself, correct?
His employer was going to be doing enumerated activities on the.
His employer was going to hire a subcontractor to abate the asbestos if necessary, correct?
Correct.
Okay.
But the work on the subway tube would have also included work by his employer, NICTA. He was also going to
I
continue
mean, other works
doing-
outside of manhole 35. He would have
Outside, yes.
he had other manholes to go visit or other parts of the system to go visit, correct?
Yes, and in fact, both sides said that this was going to be ongoing through the whole project. TCE
Is there
testified,
any evidence that he himself had any other role in this construction project other than just going initially to check?
no, he
particular
didn't.
manhole?
But there was
So
also,
he had no ongoing role that he was going to play in subsequent steps of this construction project?
that's correct. But there was also a case where the Grand Central Terminal was being under construction and the man's only job was to do asbestos investigations. But it was ongoing through the entire construction work of the
But
Grand Central
is
Terminal.
there any evidence that this work was going to be ongoing? And we certainly make sense that first you have to see if there's asbestos. You're not going to do a remediation if there's no asbestos, and then people can come and do the construction project. That makes sense. But is there any evidence in this record that Mr. Cunningham was going to come back and do something throughout the project? Or was it just like he came in, he checked it out, and that was the end of his job?
But TCE testified, it's, quote, "It's you do surveys ongoing throughout the whole project." So
So you're saying that this case is more like the McNeil case, where it was an ongoing construction
correct, Your Honor.
that he was involved in with his inspections?
Yes.
But is it correct that no construction had actually started at the time that Mr. Cunningham did this work?
That's not clear on the record. There may have been construction going on. Even if there wasn't,
Was there
are-
any evidence that there was construction going on at the time that Mr. Cunningham was doing that work?
Not that I can refer to, but I do refer you to another case called Doskotch.
No,
versus
it's okay.
Kawasaki.
She asked you a factual question.
I know,
You'll have
but
time
in
on
Justice
rebuttal.
Scotch,
You'll have
there was-
time, counsel, you'll have time on rebuttal. She was asking you a factual question, not about the other case.
appreciate
Thank
that.
you. Thank you. You have time on rebuttal.
May it please the court, Jessica Smith for the City of New York. So as this court already touched on in their questioning of plaintiff's counsel here, this order must be affirmed because the Martinez case directly.
So why isn't this more like some of the later cases that have been cited, or the cases Pratt's and Gallagher and McNeil, where this was part of the overall construction project that was being performed, even though it might have been a preliminary step, it was part of that overall process and therefore should be afforded the protections of the labor law?
So if we compare this to Pratt's, so Pratt's essentially, you had someone who was a member of the construction team who would have a future role at the exact moment of what he was doing an inspection.
But isn't the issue really, not the role, the actual role of the person, but whether or not that person is doing work that's essential and integral to the work, meaning it can't move forward until this part of the job is done?
No, I actually would not say that that's the standard. That's and I think Martinez tells us.
That's in McNeil. That's why I phrased it that way.
That's actually not the standard. The standard would be if he was, for particularly in inspections, if it was ongoing and contemporaneous with the work like we're seeing. And here we have a multi-phase approach to the project, which
Isn't it sort of putting form over substance by saying he was in the first phase and it has nothing to do with the construction? Because my understanding is the construction project wasn't going to be able to start until somebody went in to see if there was asbestos and somebody else came in to abate the asbestos in the event it was there. Otherwise, the construction project for which everybody had contract was never going to start. So it seems that some of the cases that have come out after Martinez may have been looking at a more comprehensive or a broad way of looking at the 240 subsection 1 for this type of work.
So he has to be a member of the team that is going to be engaged in the construction project. And essentially what
Is there a case that says that? That he has to be a member of the team?
I believe that's discussed in Pratt's, but if I can also point you to your own, this court's decision in Toro. Toro is essentially, it's the same employer doing two different phases of a project, and it is cited in the brief. So you have them, I believe one
phase was a demolition team, and then you have a second phase, which essentially the cleanup team, they were just going to put the garbage at the curb. Plaintiff, same employer, same overall contract. Plaintiff's role was strictly limited to putting the garbage at the curb, which was not determined to be an enumerated activity, and he was outside labor law 241 and 241(6)'s protection. So that's what I would point you to that particular case, because we have something very similar here, where arguably there could be another member of another team later on, which here would be an asbestos remediator subcontractor that the transit authority would hire. So that's why I would see us in like a Toro situation, which kind of piggybacks off of Martinez, which we were talking about earlier, rather than something like Pratt's, where he was going to be there the whole time. He had been working the entire time. This just at that moment, he was doing what was called an inspection, but really he was just inspecting the work that he had completed previously. So
Does the record address the timing of this work versus the start of the actual construction work?
right. So in order to begin the work, everyone had to do essentially different surveys. They needed this was transit. Transit was looking into whether their asbestos remediation had been done previously and whether there needed to be a remediation.
This was the very first step in the whole process.
Right, and then as I understand, there are other contractors that had to do their own, surveys, but they couldn't even enter these areas until they had been essentially cleared for asbestos, because you need a particular licensure to even be in the manhole. And
No part of the construction had in any way yet begun, because first all these preliminary steps had to be taken.
right, it's an investigatory phase. They didn't even know what work had to be done before we did this asbestos inspection for the presence of asbestos. And then even then, they had to submit the samples to a testing agency. That agency had to get the results, and then only then when they had the results could they even say what work needed to be done. Now, just with my remaining time, I just would briefly like to pivot to the Labor Law 200 claim against the city. I know plaintiff didn't get to address it, but here the city's been out of possession of the transit system since 1953. We have plenty of case law saying that they're not
A possession landlord.
actively negligent. Thank you.
Good afternoon, Your Honors. Daniel Rosenblum for Defendant TC Electric. Now, very quickly, not to belabor this point, but I would just like to clarify something about the McNeil case and the cases that cite to it and that line of cases articulating the integral and necessary standard. So I'm going to read directly from the Court of Appeals decision in Martinez. We reject the analysis employed below, which focused on whether plaintiff's work was an integral and necessary part of a larger project within the purview of Section 240. Such a test improperly enlarges the reach of the statute beyond its clear terms. That is the statute used in McNeil. It directly contravenes an express mandate by the Court of Appeals. It is bad law.
So you're saying that McNeil runs athwart the finding in Martinez?
Precisely, Your Honor. The true test is whether...
Was McNeil reversed by the Court of Appeals?
I believe the McNeil case was handed down after Martinez.
Yeah, I'm aware of that. That's not my question. My question was, you're saying that McNeil is bad law. Was it reversed by the Court of Appeals?
No, Your Honor, I believe it was just ignored, but
Well, I mean,
perhaps...
the law sometimes does, it wasn't mentioned, I'll grant you that, in the decision. Martinez was not mentioned in McNeil, but sometimes the law changes. I mean, Martinez was 25, 26 years ago, so sometimes the interpretation of the statute does change a little bit, right?
Your Honor, respectfully, this court does not change Court of Appeals case law.
Do you have an argument? I get what you're saying. We're not allowed to ignore what the Court of Appeals says. But do you also have an argument that to distinguish McNeil as opposed to just say that it's wrong law? Do you have another argument that you wish to make that McNeil on its facts is distinguishable from this case?
Your Honor, I don't recall exactly what McNeil stated off the top of my head. If Your Honor would like, I'd be happy to write a letter to the court.
No, that's okay. I was just curious what your argument was.
What I can do is pivot to an alternative argument specific to TC Electric, and I believe the Lero defendant.
You're not a statutory defendant.
Precisely, Your Honor. It's the plaintiff's own admission, as clear as day, that the TC Electric individuals present at the work site had no authority to direct and control his work.
And your work hadn't even yet begun yet at that point.
Precisely. And,
Which is why there's the question of whether or not this is part of it.
and, Your Honor, by contractual mandate, the plaintiff in this case was an employee of the Transit Authority who hired TC Electric. So even if the work had begun, we had to defer to plaintiff and everyone else from the New York City Transit Authority by express contractual provisions. We had to permit them to be on the site. We had to coordinate our work with them. We had to cooperate with them, and we could not interfere with the things that they were doing.
Was there any evidence in this record that TC had started to do any of the work which it had contracted with the Transit Authority to do for this project?
No, quite the opposite, Your Honor. In fact, the record is very clear that no actual enumerated work could begin until after all the inspections.
Which
not
makes
just at
sense,
manhole
right?
35, precisely. Because otherwise, why have them in the first place if other people can come down? Now, as far as the work being contemporaneous with the inspections, here's what actually the record reflects. Now, with respect to the ongoing asbestos surveys, what the witness actually said, and this is Nal Bone, this is TCE's representative, that they would go into the tunnel on a shutdown to see if the drawings match up, and started doing most of the surveys. You do an initial walkthrough of the entire tube just to get your feet wet and understand where everything is, but you're continually doing surveys through the whole project. And that is on the record, pages 2001 to 2002. What that reflects is that the surveys that Plaintiff's Counsel referred to that were going to continue through the project were not asbestos surveys. There are other surveys to be done. Asbestos had nothing to do with TCE's responsibilities at the work site, and that brings me to another point just very, very quickly before I sit down. The brief to which we responded is rife with factual assertions with a very attenuated relationship to the actual facts in the record. Now, I make no accusations, but I do encourage this court, when Your Honor sees assertions in these briefs that say that inspections were ongoing or the contract says this, please check the citations, and you might find a different story reflected there.
Thank you.
Thank you.
Good afternoon. May it please the court, Nicholas Calabria with Omni Demirs McManus for the Lero defendants. Just to address the McNeil case, I believe that this case is distinguishable. In that case, the plaintiff, though he was doing inspections, he actually tripped and fell where actual abatement was ongoing. So there was construction work actually going on at the time when he was performing his inspection.
So for the defendants to have won in that case, they would have had to have the court accept that asbestos abatement is not part of a construction project, because clearly the abatement was already ongoing at that point in McNeil.
Yeah, that was the construction that would trigger 240.
That's a different issue than this case, which is whether the pre-work to even determine if asbestos exists as part of the construction.
Solely, no abatement was going on, no other construction was going on. He was just going down into the manhole or the electrical closet to inspect to see if there was any asbestos there. He would then take a sample, it would be put in a bag, it would be taken to a lab, it would be tested. They would be doing manhole after manhole after manhole, and then a report would come out, go to the city would then hire an abatement contractor, which wasn't even involved yet in the construction work, who would then abate it, and then the construction work could finally start, which TCE and Lero was overseeing. So it's completely different than the McNeil case. And it's right on point on the Martinez case, I believe. Now, I did want to address one thing in an attempt to...
We don't have to, according to you, we don't have to decide that McNeil is wrong to come to the result that you wish.
It's just distinguishable based on the facts. And in this case, the plaintiff's brief made some insinuation that there was some ongoing construction work because that there was a claim that there was water drained from this manhole prior to the accident, and that's not true. The pages cited in the deposition transcripts does not say that. They said that if there was a complaint of water being in a manhole, TCE would hire a contractor to come and drain it, but that was not done in this manhole number 35. And there is a...
So there was no draining of water preliminary to or contemporaneous with Mr. Cunningham's work?
Yeah. And in fact, at page 568 of the record, the first time that they attempted to do work at manhole 35, to do the survey work, they couldn't do it, and it's noted in page 571 that the reason that they couldn't go forward was not because of water and it had to be drained, but rather that the ladder wasn't big enough. So that's documented in the record. And then they went back the second time, and that's when the accident happened. I believe there is no basis for reversal of the Labor Law 200 claim. Lero never was at this manhole prior. They did not look in the manhole or go into the manhole with the plaintiff. Only the plaintiff was going in. Only the qualified inspectors could do that. He even said that he could tell, if they attempted to, the plaintiff said I could stop them from doing that. So they had no notice of what was in that manhole.
He was preceded by Mr. Rampersad, right?
Correct.
But Mr. Rampersad is also a transit authority employee?
Also a transit authority, also had an inspector's license. So those are the only two that were in the manhole. So Lero never had a chance to even go in the manhole to inspect it, to say whether or not it was a dangerous condition there at all. So therefore, the labor law claim 200 claim should be dismissed. Thank you.
Thank you.
To my knowledge, that there was testimony that there was a removal of flood water prior to the accident, prior to the...
Is that citation in your brief we can look for?
Yes, yes, there is a reference in my brief. Does the court have any...
What follows from that, though, if that turns out to be the case, that there was water drained from the bottom of this manhole? What follows from that? That somehow the construction had started?
Well, I don't have any evidence that there was actual, construction on this project started at that time. That's not what I found. I did find testimony that there was water removed from this, so that there would have been notice, because TCE was supposed to do the water removal from the flooded room. If TCE was in there, then they would have had notice of the catwalk being dilapidated.
Okay, so that's a 200 claim or common law
negligence? It's a 240 claim, because I can't have a fall from a permanent structure. I have to say the permanent structure was dilapidated, and a foreseeable risk of harm would have incurred from using it. A foreseeable risk of harm, I would need TCE to be in there and have seen the catwalk.
Any other questions? Thank you very much.
Thank you, Your Honor. I really appreciate your time.
Williams versus McAlpine Contracting.
Good afternoon, Your Honors. May it please the court, my name is Mark Jordan Poinsett. I'm counsel for third-party plaintiffs, respondents, appellants, McAlpine Contracting Corporation, the general contractor, and Sandy 350 LLC, the owner of the building. We're seeking a modification of the July 26, 2023 order granting McAlpine and Sandy summary judgment dismissing the Labor Law 241-6 claim based on a claim violation of Section 23.1.7E. Quite frankly, this is not a 23.1.7E case. Plaintiff did not trip in this case. He's on the structure. He's on a permanent structure.
There was no allegations of dirt or debris.
That's correct. This passageway is clean according to plaintiff's own testimony. If we're even going to consider it a passageway, it was not a space that he should have been in necessarily, although he had been in this space 2 to 3 times earlier in the day, carrying materials at the other times, and had no issues traversing this this concrete permanent structure that he was on. We believe that the lower court erroneously determined that the expert affidavit created a material issue of fact, mainly because he's just considering this a dangerous condition on the premises when it's not a dangerous condition on the premises. This is an actual structure on the premises that's going to
Why isn't it a dangerous condition, though? If there's a factual issue as to whether people were using this pathway or not, and whether or not they were permitted to use this pathway, which there clearly is, why isn't there an issue of fact as to whether this curb constituted a dangerous condition because of where it was located in the pathway, and that in order to traverse the pathway, you sort of had to go on the curb?
So plaintiff said at certain points in the pathway, there's varying testimony as to how wide this actual pathway was, and plaintiff's expert in his affirmation states, at its smallest, it's 1 foot and some inches, at its widest, it's 3 feet. The curb is not in the middle of this pathway based on the testimony on the record. Plaintiff says he has to hop on the pathway at certain points, but he's aware of this pathway. It's open, it's obvious, it's clearly a structure.
Testimony, which we have to accept for purposes of this motion, is that he could not traverse the pathway without dealing with this curb and going on this curb. Why wouldn't that raise factual issues as to whether the location of it was a dangerous condition, which they had notice of?
I would say it's not a dangerous condition because, again, he steps onto this onto this curb. He's tiptoeing like a 5-year-old on a fence. He's going 1 foot in front of the other. He admits he doesn't trip. He actually rolls.
I'm sorry, why isn't that a dangerous condition if it was the only way he could navigate there?
How he's navigating it is not the dangerous condition. He's walking on this. He falls off because he rolls his ankle. He doesn't fall off because this actual structure is any sort of danger to him. He doesn't trip over this. He doesn't trip on anything on this. He's walking on this, and the testimony as far as other people walking on it, no Bedrock employees walked on this.
Right, but isn't there a factual issue or an issue as to whether if someone's forced to walk on this raised curb, there's a risk that they will fall off it?
I understand what you're saying, Your Honor. He was not forced to walk on this raised curb. There were multiple other paths he could have taken. That's correct.
And I believe that he testified that he went to ask someone, I see the plywood that's blocking this area. I need to get back to the storage, office. And she said, oh, well, everybody's walking this way. There's at least testimony that some people were walking that way, whereas there's other testimony that people weren't supposed to be walking that way. It seems to me that's an issue of fact. And once he thought that was the way to go, he claims it was a dangerous situation that caused him to fall. Not necessarily debris, but a condition.
May I respond quickly?
Yes.
It was his first day on the job. He missed his morning meeting because he was at a site orientation.
He was at a new person's meeting, right?
Yes, correct. And, Bedrock's foreman said, or their project manager said, there was at least 2 other paths he could have taken. He never asked. And the person that he got the advice from, as far as this cleaner person, she didn't have any authority to actually direct him to use this.
He may not have known that.
Okay. Thank you.
Thank you.
Good afternoon, Your Honors. I represent Bedrock third-party defendant. Justice Rosado's decision should be affirmed in all respects. Plaintiff's counsel moved for summary judgment, and plaintiff's counsel did not move for summary judgment on his 241-6 claim, but he demonstrated an issue of fact in opposition to McAlpine's motion. We opposed McAlpine's motion by pointing out that there were issues of fact concerning McAlpine's negligence. There's no inconsistency in Justice Rosado's decision because the questions of fact she found concerning the tripping hazard, which you recognized, constitutes some evidence of negligence on McAlpine's part because it's allegedly a violation of the industrial code. We also argued that there was no basis for arguing that Bedrock had breached its contract to procure insurance. Justice Rosado accepted our arguments that
it's definitely, you concede that the contract did require Bedrock to obtain insurance, correct?
Yes, certainly. Yeah. And we did. The primary coverage is defending
Did the burden
McAlpine
shift
now.
to you, though, counsel? Did the burden shift to Bedrock after they had proffered various insurance policies that you told them about, and they all were outside the date of occurrence? In other words, once they said, yeah, you told us about these insurance policies, but they don't apply because they didn't cover Bedrock during the relevant period, then did Bedrock have to come forward with saying, well, here's the insurance policy that did apply?
I'm frankly not familiar with that issue.
Maybe I missed something in the record. Did you put forward affirmative proof that you did have an insurance policy that applied during the relevant period?
For primary or for excess?
Either?
I don't think so. I don't think we did.
I mean, normally it is the burden of proof on the other side to show that you failed to obtain the insurance in derogation of the contract. But
sorry,
go ahead.
I would say the excess, whether there's the primary is defending them now, and the excess has not been triggered because there's at this point no indication that the primary policy will be exhausted. So whether there was excess coverage at the time of the incident is not really an issue. That's if court has nothing further. That's what.
Thank you. Thank you very much.
Thank you.
I just want to briefly address the excess issue. The issue was we did meet our burden in the underlying case, but the policies that were provided were not for the proper policy period. So in response, they eventually did get us the proper policies, but those are not before.
They're just not on the record right now. Okay, thank you.
That is correct. And just going to the indemnity issue, I mean, this is a clear, broad form indemnity provision. This clearly arose out of
But
plaintiff's
there's
work.
still an issue of fact as to your own negligence. If we find that there's an issue of fact as to dangerous condition, then you wouldn't be entitled to indemnification yet.
That is correct. Judge Rosado.
So it depends on what we find on the other issue, whether or not we agree with that part.
That is correct. But Judge Rosado had dismissed Labor Law 200 and common law negligence against us in the same order, finding that there was somehow, that's why we're saying there was an inconsistency, because she found that there was a question of fact, yet she had dismissed the 200 and common law negligence claims against my clients. As far as we already addressed the industrial code. Again, this was not a tripping hazard in the same sense. It should be under 23.1.7, and this was not the proximate cause of this incident. Plaintiff rolled his ankle.
Thank you.
Thank you.
Suazo versus 501 Madison Sutton.
Good afternoon, Your Honors. May it please the Court, James Drexler, Galavitucci-Clark for the defendants, appellants, 501 Madison Sutton and GC Contractors, Inc. This plaintiff in this action claims that he fell from an A-frame ladder, which caused him injury.
We all saw pictures of that ladder, and I don't know if I would have gotten up that ladder.
Be that as it may, Your Honor, plaintiff's account of this, his multiple accounts of this testimony is completely inconsistent.
Why does that matter? Even if we assume what you're saying is true and that there was some inconsistency, why would that ultimately matter? Under all the various versions, how does that undercut plaintiff's ability to get summary judgment on the 241 claim?
Well, because the inconsistencies put plaintiff's very credibility at issue, and he was the only witness to his accident. So
There's no dispute that he fell off the ladder.
there is no dispute that he fell off the ladder.
What's the biggest discrepancy as far as you're concerned? The 12-foot versus 6-foot, or what?
No, those were just inaccuracies that were, and the ceiling height as well. The biggest one from our point of view is that he first said that the ladder shook and then fell. And then just moments later, he said the ladder did not shake, it just fell. And that's on the record at 314
But I
and
mean, he
315.
did fall off of the ladder. So the ladder was supposed to be protecting him so that he could do his work. He was holding, I believe,
Plaster and a spatula.
Yeah, and a spatula in one hand and spatula in another, and he fell, and all those things fell down with him. So whether it shook or it fell, or
That's right, but
I mean, what's the difference?
Well, respectfully, he also testified, and this is at the record at 312, that as he was going up the ladder, he didn't notice or feel anything that made him think it was unstable. He worked on it for 2 minutes. He didn't feel anything or notice anything that led him to believe that it was unstable.
How is this different from the Caceres case in 2015, where a worker likewise was standing atop a ladder, was drilling and fell because the ladder moved? How is this different?
Well, I don't have that case right in front of me, Your Honor. I believe there was an actual defect to the ladder, and that goes to our second point, which is that our expert testimony.
Your expert didn't look at this ladder, this particular ladder, right?
No, but this court has held in no, I'm sorry. I have a case site for you, but this court has held that it's not speculative because she looked at pictures, and that's enough under this court. That was Potter v. NYC in 2004.
Even if a ladder is not defective, though, if it's not suitable for the task at hand to protect the plaintiff, isn't there still a cause of action?
Well, that goes to the question of what happened on the ladder, and that was exactly what the expert said, which is that the only thing he noticed was that spacer between the A-frame, and the expert under the American National Standards Institute said that that spacer between has nothing to do with load-bearing capacity. Nothing at all. So plaintiff is not even arguing that he didn't have proper safety devices. He's arguing that the ladder, the spacer between, was bent, which caused the ladder to fall. But again, the expert testified and put in her affidavit that that spacer has nothing to do with load bearing. So in our view, plaintiff has not set forth.
Load-bearing argument, I take it, but I think that has to do more with their 241 sub 6 claim.
That's correct, Your Honor. The only industrial code that was alleged to be violated was that proper weight or proper load management of a device like a ladder, and that goes out the window with the expert testimony. But again, the court below completely disregarded the expert testimony, and that testimony, that affidavit, creates issues of fact. Like that's what we're arguing here, is that there are enough issues of fact between the inconsistencies and between this expert testimony, which was disregarded, that summary judgment is just, summary judgment is really precluded because of these issues of fact.
Thank you.
May it please the court, John Shore for plaintiff respondent. First of all, as this court knows, the plaintiff doesn't have to show that the ladder was defective. The plaintiff has to show that the ladder was an unsuitable device. And in fact, their expert, who should not even be considered, experts who are from Pennsylvania, who, whether she was from Pennsylvania and wasn't licensed, doesn't even matter.
Yeah, you say that she's an abject smokescreen in your papers, but she has pretty fancy credentials. I mean, why shouldn't we listen to her? Why doesn't she create an issue of tribal fact?
Because she does not understand what the labor law section 240-1 constitutes. In fact, in her so-called affidavit, she acknowledges that the ladder moved. The ladder failed, and counsel is distorting the record. First of all, as this court knows, in the Marino case and the Wasilewski case, the ladder doesn't even have to fall, but there's nothing to even contradict that the ladder moved, whether it moved or jerked. It precipitated, uncontroverted, that my client fell down with the ladder. He never contradicted himself, and that is an incontrovertible fact that they did not get a witness to dispute. And as this court knows, which their expert did rely on, and certainly in part, whether the ladder was 8 feet, 12 feet, or 4 feet is totally a red herring, and that was based on her review of the photographs. In fact, on a panel that Justice Kapnick sat on in Sanchez v. 1 Burgess Road, 195 83rd 531, this court made it very clear whether he, meaning the plaintiff, fell about 6, 8, or 20 feet, or whether he fell directly through the middle of the scaffold is not dispositive since the statute was violated under any version of the accident. And here there is only one version, and
Was he the only one in the room when he fell?
correct.
So we're never going to have anybody that's going to be able to testify. We could wait 30 years. We're still not going to get anybody else to testify. His testimony is always going to be, this is what happened. I was on the ladder. I was doing the work I was told to do, and I fell off the ladder because it didn't protect me.
As simple as one of hundreds of labor law section 240(1) cases as this court has had, but in fact, this ladder was clearly not a good ladder, even though I don't have to prove that. Although the expert said, despite the fact that the ladder was bent, that does not mean it wasn't a suitable safety device, which is palpably ridiculous, not to mention that she acknowledged that the ladder moved. And under cases I cited to, even if a plaintiff technically did an unsafe act or did something they knew they should not have done, if they were told to do it, like in the Garcia case, Garcia v. 122-130 East 23rd Street, 220 AD 3rd 463, which Justice Gessmer was a panel member of. In that case, the plaintiff set up the scaffold and complained to his supervisor, hey, these are mismatched parts. Supervisor said, too bad, set it up. Plaintiff is up on the device and he falls. 240(1). The DeRose case v. Bloomingdale's Inc., 120 AD 3rd 41, 214 case before this. In that case, the plaintiff was directed to use a ladder, although he said, hey, I should have used a Baker scaffold. The foreman said, too bad, you used the ladder. Plaintiff falls, this court says he can't be a recalcitrant worker or the sole proximate cause, 240(1). Here, plaintiff was directed, again, it's uncontroverted, by his boss, Sammy, to, hey, you use that ladder, even though my client said, I think a scaffold would be more warranted. And in fact, Sammy helped lift up the ladder at his direction. So you can't say he was a sole proximate cause here. And clearly, the ladder was an unsatisfactory safety device. And another, thank you.
Cruz versus Angamarca.
Good afternoon, Your Honors. May it please the court, my name is Travis Wong for the plaintiff appellant.
Counsel, I'm going to start with an issue that was not raised by the parties,
Okay.
but appears that it might be dispositive. Under our rules, you're not allowed to bring an appeal of a motion unless you're an aggrieved party. And here you are the plaintiff, and you were successful in the motion. The defendant moved for summary judgment, and the defendant was denied summary judgment. So under that rule that you cannot move unless you're an aggrieved party, why do you have standing to pursue this appeal at this point?
So even though plaintiff didn't move, plaintiff did ask the court to make a determination as to
Right, but the plaintiff didn't make any kind of motion, nor could the plaintiff make that kind of motion. It would not have been an available motion for the plaintiff to make, to have the court make a determination in a vacuum as to whether or not the reckless standard or a normal negligence standard applied. You wouldn't have been able to make that motion. So why can you?
I mean, it was argued before the Supreme Court, and the court declined to make a determination on that. And I
understand that, but the law about appeals is that even though a case may contain language or reasoning which a party deems adverse to its interest, does not furnish it with a basis for standing to take an appeal. So how do you get around that principle that, yes, clearly an issue, well, it's debatable whether an issue was decided that's adverse to you, because it's not clear exactly what the court did or did not decide. But assuming that it did, why how do you get around that rule that that's not enough to take an appeal?
I would disagree with the court and just say it is enough. It is enough, and plaintiff is agreed by the court declining to make that determination.
But you didn't move for the court to make that determination. You didn't ask the court to do that. You just hoped that maybe they would in the course of their discussion. They didn't. Is that enough to allow you to appeal?
I would say yes. However, I understand what your honors are saying. If you'd like, I could argue the point of the legal issue on appeal, just that the issue on appeal is a legal issue that should have been determined by the lower court. It wasn't made in a vacuum. It's made based on the facts, and that's whether or not a refuse truck is exempt from the rules of the road under 1103B.
Right, and if the defendant had made an appeal, then that would have been an issue that would have been appropriate to grapple with on this appeal, but defendant didn't, or I guess withdrew their appeal, so we don't have defendant's appeal before us. Defendant could have said, hey, the court erred in the way it analyzed the issue.
Understood, your honors. I would just, just on the legal issue, I think it is a legal issue that should have been determined by the court, and plaintiff is aggrieved by the court's failure to determine that issue. And the law is clear, especially in light of the Court of Appeals case, Riley v. County of Broome, that the two exemptions under VCL 1103 subsection B are distinct and separate, and hazard vehicles are not entitled to an exemption from the rules of the road. If you have nothing further, I will save my rest for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Danielle Hoffman. I am attorney for the respondents. Regarding the standing issue, should this court entertain plaintiff's position despite it not being properly raised before this court, I'd like to just respond to his analysis of what the statute actually indicates. So just to further address this court, the lower court actually did make a ruling as to whether or not—
Did the court make a ruling, though? It's not entirely clear whether the court actually did make a ruling as to what standard it was or was not applying.
Well,
Is your position it did make a ruling?
It did, Your Honor.
And there was a motion to re-argue, which was denied, correct?
Yes.
Is that in the record?
Yes, it should be.
The decision is in the record.
Yes. So based on the VCL Section 1103, as counsel had indicated, the Move Over Act, which is codified by VCL 117A and VCL 1144, was amended on November 1st, 2016. And this amendment of VCL 117A was revised to include, amongst other things, waste collection vehicles while engaged in collection of refuse on a public highway. Also, the VCL was amended by—
Wasn't there a question of fact as to exactly what was going on with the vehicle, whether it was parked, whether it was finished with its work, whether it was backing up? It seemed to me in looking at the testimony, there was various conflicting testimony about what was exactly happening right before the accident.
So the decision held that there was credibility issues concerning the several plaintiffs, but the record did demonstrate that the operator of the refuse vehicle was outside of his car. He had his car parked. It was in the course of its normal routine business, and even one of the plaintiffs admitted that they saw it was parked, it had its amber lights on. So I understand that the decision indicated that there was a recklessness standard, or whether or not it was a recklessness standard was a question of fact.
Right.
But just to, I guess, circle back to what was the amendment, the cases that counsel referred to before, Riley, for example, that predates the enactment. So that enactment of 2016 also was amended to define waste collection vehicle. So this is any motor vehicle which is commonly classified as a garbage truck that is designed for and used in the collection of refuse or recyclable.
But it's not limited to municipal garbage trucks.
It's not, Your Honor. And there was a recent Court of Appeals decision of October 2024, which is, in my brief papers, it's Orlena v. Town of Carmel. In this decision, they held that in order for the recklessness standard of care to be applied, it needs to, one, be classified as a hazardous vehicle under the VCL 117A in the 2016 amendment, which as here, the sanitation vehicle was, but also that it had to be engaged in a protected activity at the very time of the accident. So just to direct your attention to another case that I had relied on, it is Shepherd versus the Town of Hempstead Sanitation District. In that very case, there was a vehicle which was a sanitation vehicle, and this is also a 2019 case subsequent to the enactment. So that vehicle was engaged in sanitation removal services, and the court held that a recklessness standard of care applied there. So here we have respondent, Mr. Angamarka, who was operating the Tully sanitation vehicle. He was in the course of his regular routine sanitation route. He was parked. He was about to go pick up the recyclables from a home that he goes to on a regular basis, and was actually engaged in the recycling and sanitation services at the time of the accident. I'd also like to point to your attention, which this is not in my brief, but this is a new December 2024 decision from the First Department. It is Soliar versus the City of New York, and in this case, the court applied the enactment of 2016. They found that the vehicle that was being operated was in fact a hazardous vehicle. However, in that case, the hazardous vehicle was not engaged in the activity at the time of the incident. They were on their way to perform the activity. So that was the only reason why the court did not consider it to be a hazardous or the recklessness standard to apply, which as here, obviously the case is very different. Another argument that counsel does make, which I'd like to address, is that he claims that their city law supersedes the state law. So just to further address that argument, because counsel argues that VTL 1642 authorizes the city of New York to establish additional rules of the road that would supersede the state of New York. So,
Right, but VTL 1103B is not mentioned there.
Your Honor, it does actually, the subsection he refers to, it does indicate that provided that VTL 1103 exempts from the rules of the road all vehicles which are actually engaged in work on a highway, it does impose such a vehicle with a recklessness standard of care. So that section does refer to VTL 1103.
Thank you.
And just to further address the...
Thank you, counsel.
Okay.
The clock messed up at your
Oh,
time,
sorry.
so
Thank you, Your Honor.
it's a little broken today.
Your Honors, I'd just like to address the legal issue here, should you decide to make a decision on this appeal. So defense's argument conflates the two exemptions under 1103B. First is the one that exempts vehicles that are actually engaged in work on the road. And under Riley, that means actually working on the highway itself, like doing maintenance, concrete work, things like that. Second exemption is hazard vehicles engaged in hazardous operation are exempt from Section A of 1202, which governs stopping, standing, and parking. In this case, here, we don't dispute that the amendment makes it a hazard vehicle. So yes, they are exempt from the rules of Section A of 1202. However, they are not engaged in the type of covered work that exempts a vehicle.
It depends what they were doing at the moment.
Yes, but in refuse collection, as a matter of law, it does not include it as work on a highway. And if you specifically look at Riley v. County of Broome, which is 95 NY 2D 455, they go into the legislative history of this code and state that this law was intended to exempt from the rules of the road all teams and vehicles that build highways, repair or maintain them, paint the pavement markings, remove snow, sand pavement, and do similar work. That does not include refuse. There's also a second department case that specifically found that refuse collection is not the type of covered work under the exemption. And the fourth department recently, earlier in 2024, I guess not this year anymore, found that the exemption does not apply to refuse collection under very similar facts. And specifically noted that in the Court of Appeals case in Riley, there are two separate and distinct exemptions which refuse collection does not, under which refuse collection is not exempt from the rules of the road.
Thank you.
Thank you.
Sorry if we ambushed you a little with the appealable issue.
Understood.
People versus Stokes.
For the appellant, Mr. Ralph Stokes, Ying Ying Ma, good afternoon, Your Honors. Ralph Stokes had to defend against two prosecutors at his trial. One was the actual DA, who argued only that Ralph was involved in a robbery turned homicide of his acquaintance, Charles Romo, but didn't specify his role. And two, his brother Keith, the co-defendant, who said that Ralph was not just involved, but was the lone killer who beat Romo to death in his own apartment.
What impact is it that we've already decided this issue in the separate appeal? We already made a determination that severance was not inappropriate. Why would we come to a different determination in this case since we already basically resolved this issue?
Yes, that decision was made in Keith's case based on Keith's briefing.
Right,
and
but
notably,
we were looking at the overall severance determination and making that
Yeah,
determination.
well,
So
We had the whole record. I mean, I was on that case, so.
Yes, I saw that, Judge. It makes sense that that was the outcome in Keith's case because he was not prejudiced at all by Ralph's defense. Ralph's defense was that I was not there when I left. Mr. Stokes was still alive. And I just want to read briefly from the DA's brief on Keith's case. The DA said that the defendant, Keith, is hard-pressed to articulate how he could have been prejudiced by the joint trial. Ralph never so much as pointed a finger in Keith's direction. Ralph's denial of involvement could not by itself have caused the jury to convict Keith. But the case before you is about Ralph, and the same certainly cannot be said.
What evidence in the Keith case or in Ralph's case, well, actually in Ralph's case, that's what we're talking about, would not have been admitted if there was a separate trial?
Judge, respectfully, that's not the standard. The standard is, was there a significant danger that the conflict alone would have led the jury to infer the defendant's guilt? That is the second prong of Mabubian, the leading severance case. And in this case, we just have no trust that the jury was not swayed by Keith's defense. We certainly know that they considered it because there was a note on day 2 of deliberations where they asked specifically about Keith's defense. They said, Judge, can you tell us if a person is already deceased by the time the defendant arrives, can he still be guilty of robbery? So we know that they were considering this. Then the day after, they told the judge that they were deadlocked on the issue. They certainly were not deadlocked on Ralph's defense. Ralph was completely hamstrung from actually presenting a defense based on the fact that there were two prosecutors in the room basically endorsing each other's theories.
I mean, did the summation by Keith's attorney preclude Ralph from arguing that another person could have committed the crime?
No, but Judge, again, that's not the standard. The standard is, was there a significant danger that the conflict alone would lead the jury to infer guilt? And in this case, we just can't say that there's no danger. We can't, even if there was a limiting instruction that the jury is only to consider the prosecution's evidence, I mean, how can we expect this jury? This is one of the last things they're hearing. And it's a completely inflammatory narrative of a hate crime of my client, going into a murderous rage after hearing that someone that he had allegedly previously had sex with, discovering that he had HIV/AIDS and therefore bludgeoning him to death. I mean, the jury could not get that out of their minds, especially when the prosecution's evidence was entirely circumstantial. It was prosecuted as a felony murder, and they had no motive for why a robbery would then evolve into a fatal beating. They didn't explain that. There was a complete omission in their case. And so when the co-defendant's attorney comes in and gives the jury a complete story about why that is, you can't expect the jury to just discount that. And we know that they didn't because of the note that they sent, the multiple notes that they sent to the court based on their deliberations. I think another point that makes it, that makes it inflammatory is that they're brothers, that these aren't just acquaintances that happen to be arrested together and they're just pointing the finger. This was my client's own brother talking about something extremely intimate, his sexuality, his past, sex partners, and presenting that to the jury. So how could the jury have discounted that? I think under the leading case, Mabubian, there's no way that we don't have confidence that the jury's verdict was based on the prosecution's evidence alone and not based on this conflict in the defenses.
How about harmless error? Do you want to address that?
Sure, thank you, Judge. Yes, the proof was far from overwhelming in this case. As I said, this was an entirely
There was a
circumstantial
lot of video
case.
evidence placing Ralph at the scene, and there was also his girlfriend, Ms. Dowdy's testimony. That seemed like a lot to me.
Sure, but there's no eyewitnesses, there's no forensic smoking gun. They tested 99 pieces of evidence from the bloody crime scene, and there was not a single piece of DNA from my client among those 99 things. There was one fingerprint on his mug.
They had the fingerprint, of course.
Yes, but that's entirely consistent with him having previously known Romo, having been to his apartment before. And again, the DA just did not provide a motive for why a robbery turned into this very vicious beating. And I do want to just note again that this was entirely circumstantial, meaning they're asking the jury to draw inferences. So the fact that, Keith's attorney gets up on cross-examination and brings out what they're going to, I guess, characterize as insignificant details, that lets them draw a completely different narrative, completely different inferences. And I think that is highly dangerous in a case where the DA's evidence is circumstantial. In Mabubian as well, the prosecution's case was circumstantial, and the Court of Appeals specifically noted that because it said that then increased the danger that there would be, undue weight, extra weight given to the government's case based on just the conflict and the antagonism of the defenses.
Thank you.
Thank you.
Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people.
Counsel, what do you make of the argument that in the summations, the co-counsel made all of these assertions about the possible motive behind this crime? How do you respond to that?
So first, I'll just open by saying this is a felony murder case. The people were not obligated to establish a motive to kill. They established a motive to commit robbery, which was all the people's burden in this case. So there was no gap, an evidentiary gap in the people's case that was filled by establishing a motive to kill. The summation was undoubtedly extremely inflammatory, but the summation wasn't based on any evidence at all. Counsel just stood, we heard from opposing counsel about how allegedly Keith made all these accusations about Ralph having had prior sexual relations with Mr. Romo and Ralph learning about Mr. Romo having AIDS. But none of that came out in the record at all. In fact, Keith never made those accusations. Only Keith's attorney stood up at summation when the case was already proven very strongly against Ralph and tried to pin the whole thing on Ralph at that juncture. But this
But he did use circumstantial evidence in his summation, and he summarized it and said this is why you should find that Keith is, should be acquitted on murder.
He used circumstantial evidence brought out exclusively on the people's case, and the circumstantial evidence in its entirety in no way meaningfully supported. I mean, even counsel in her brief describes it as a series of speculative leaps that defense counsel took in order to support the claim that there was some HIV-based, rage-fueled attack. There was no actual evidence of any kind in the record, and I just want to hit on the issue of
the argument was adversarial to Ralph. You have to concede that.
I concede that the argument was adversarial, certainly at summation, but if you read the record closely, Your Honor, I don't believe that there was actually much contest between the two. Certainly it came up in the pretrial hearing about severance that Keith was going to pin the whole case on Ralph. But if you actually read the record, that's not how the trial progressed. Really, Keith's attorney made no serious effort to pin the blame on Ralph throughout trial. And so when he tries to, at the end of summation, sort of retroactively blame the whole thing on Ralph, he does so, he can only do so on the basis of sort of blind speculation because he didn't build an evidentiary record sufficient to support the claims he was making. And I just want to highlight, as we're talking about the case being circumstantial, because counsel notes that the people's case was circumstantial and sees that as a flaw in the people's case. Circumstantial does not mean weak. Any law student can tell you that. And if ever there was a case that could guide you to that principle and show you that a circumstantial case is not per se a weak case, this is that case. And of course the people could only establish a circumstantial case. The only direct evidence available would have been Charles Romo's testimony, obviously not available, or the testimony of the two brothers, which obviously we could not force. So we had to present a circumstantial case, but we presented an extremely powerful one. Not only, and again, Ralph's counsel conceded this, not only was Ralph visible on camera arriving and then leaving from Mr. Romo's house on the night of Mr. Romo's death, and visible on camera leaving with Mr. Romo's property, but the very next day, when Mr. Romo had died overnight, Mr. Romo's phone, which had been with him when he died,
No, I know. And they had the ATM card. They had some of other property.
There were a bunch of other things that corroborate Ms. Dowdy's testimony as well, which was also very persuasive, notwithstanding her conceded record of being dishonest in court. Her testimony was powerfully corroborated by a series of objective considerations, as you say, Your Honor, the ATM card, the phone, the injury to Keith's hand. There were all sorts of ways in which we could show that what Dowdy was saying was clearly accurate. So circumstantial the case may be, but that does not make it weak. The case was extremely strong against Ralph. And there is no reasonable possibility, and this is the core, I think, of our argument, there is no reasonable possibility that, and I want to give you Mabubi and Standard directly, that there was a significant danger that the conflict between the defenses alone was going to lead the jury to infer Ralph's guilt. They didn't need that. Ralph's guilt was incredibly obvious on the face of the trial record that the people offered. I'll just say that this case should be pretty straightforward on the basis of the evidence against Ralph. Ralph was guilty, and there's no serious contest about that. If Your Honors have no further questions, I'll leave it at that. Thank you.
Thank you.
Your Honors, my adversary is basically asking you to discount what happened on summations, but how can you discount what happened on summations? That is one of the most important, if not the most important part
Counsel,
of the trial.
Do you agree with counsel's statement that in the course of that Keith put in or was not able to establish through cross-examination anything evidentiary against
No, I don't agree with that. There was certainly a lot that was built up through cross-examination that, supported his theory as to the timing, the fact that the bleach was poured on the body after death. He used that in summations to say there wasn't enough time in the 40 minutes that Keith was in the apartment to engage in the bludgeoning and also clean up. The fact that Shaquana Dowdy, initially lied to the police and exaggerated Keith's involvement. They used that to argue that, she's biased, she's protecting her boyfriend. All of these things, I think, matter in a circumstantial evidence case because they bolster this entirely different narrative that they presented in summation. So it's, it's not insignificant. And I'll just say again that summation is important. The fact that it's the last thing the jury hears, and we know that it was, in their minds as they deliberated through the 3 days of this trial. There's no way that the jury could have discounted the incredibly inflammatory narrative that was presented at summations.
Thank you.
Thank you.
Ostrager versus Chaffetz.
Good afternoon, Your Honors. Glenn Ostrager for the appellants. The plaintiffs initiated this action after defendants breached a purchase contract for a co-op apartment. The contract is at R21. Defendants failed to comply with conditions for closing pursuant to an express...
Counsel, the contract provided that the apartment was purchased as is with a couple of exceptions, correct?
That's correct.
All right, so we're talking about the windows, and we're talking about the HVAC.
That's correct.
Right? So both of those things were working. Your architect says so. Case over or not?
The architect did not say that those were working.
The architect in their report said that the units, that talking about the HVAC, the units are noisy when operating. So they're operated.
Well, let's address that. The units, he said the units were quite noisy. We submitted the Ostrager affidavit to amplify the pleadings, and in that affidavit, we stated that the unit in the dining room could be heard throughout the entire apartment, and so at some level, and the architect further stated in his expert inspection report that that two units which were in question were at the end of their useful life.
But wasn't all of those things we read, But wasn't it true that the contract that you entered into, the sales contract said the appliances shall be in working order at closing? It doesn't say should be brand new, doesn't say they should be in great working order, doesn't say they should be working quietly. They just said they're in working order. They were in working order. They may not have been as good as working order as you would have liked, but that's not what the contract says.
Well, with all due respect, there comes a point when the level of noise is such that the air conditioning unit is not.
But your contract could have specified that it not be noisy, but you didn't specify that. You only specified that it be in good working order. And your architect confirmed that it was in good working order, but it made a little noise.
Well, good
You're,
working.
I mean, you,
I'm sorry.
I clearly know how to write a contract, and this contract didn't have anything in it about noise, either by the HVAC system or the sashes rattling on the windows. The only issue was good working order. I don't see anything in the architect's report that shows that either were not in good working order. Can you show me anything that shows they're not in good working order?
Yes, I think we have to start with the definition of good working order. Good working order required, in this case, that the windows.
I hate to say this, unless I'm wrong. Does it say it should be in good working order or just in working order? It doesn't even say good.
It says working order for the HVAC units.
Right, so working order means it works. There's no question that the air conditioning worked. So that's all that it's required, is that it works. The architect didn't say that it didn't work. He just
The definition for working order in Merriam-Webster Online Dictionary is a condition of a machine in which it functions according to its nature and purpose.
And where in the architect's report does it say that it was not functioning? It doesn't say that it was blowing hot air when it should have been blowing cool air. It didn't say that it shut off and shut on and it wasn't running. It was operating.
It says that the units were at the end of their useful life. I'd like to, if I could, turn to the windows.
Now, there was one window that wasn't working, right? That actually would not stay open, and that was fixed, correct, by the seller?
No, at the original.
That didn't happen at all?
Yes, that did happen.
Okay.
There were 7 windows which were fixed shut.
But the one that wouldn't stay open, they fixed that one, right?
There were newer units, and there were 7 old units. The old units were fixed shut, and that led to a discussion, which is, set forth in the Ostrager affidavit between the parties about providing that the windows would be in good working order at the time of closing, and so at the pre-closing inspection report, the windows had been serviced, but they were not in good working order.
You'll have time on rebuttal, thank you. You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. Joshua Krakowski for the respondents, defendants, the sellers in this case.
Counsel, as to the windows, in plaintiff's architect report, the assessment is that the windows are in poor condition and have not been maintained for proper operation. How is that good working order?
Well, Judge, they're not mutually exclusive. Something can be in poor condition but also be in good working order. Take a 20-year-old car. It might have a top liner that's coming apart. The top is coming down. It's old. It has dents, but it still goes. Gas works. Brakes work. It gets from point A to B. The windows work. The windows are in good working order. What is not working about the windows? Light comes in.
They're capable of being opened and closed and of staying open after being open. Were they in that condition?
Of course. And then there's no allegation to the contrary.
Was there one that you fixed after the architect's report?
Yes, and that's it's not in the briefing, but it is in the record, as Justice Moulton said. Yes, we did fix one window that would not stay open. We fixed that. It was a $7,000 window. We said, we'll do it. The rest of them, they all stayed open. They all open, they all close. There's nothing about these windows that don't work. The only thing that doesn't work, what the appellant says, is that the outside exterior wood needs to be caulked and painted and some sashes rattled. Like, these are really not things that affect good working order. You know, good working order, there's not many, surprisingly, there's not many cases that talk about good working order and what that phrase means. But both sides cited this Padovano case from the Third Department in 1995 that said good working order means operational and adequately perform their intended function. This is straightforward language. What does it mean to be in good working order? Nothing about these windows don't work. There's no claim here for material breach. They didn't want to close on time. We have a contractual right to take the deposit, which we did, and that should be the end of the case. So unless there's any further questions, I'll give my time over.
Thank you.
The question regarding the window that was replaced was not after the architect's inspection report. That was something that I would acknowledge that the seller took care of.
When you entered into this contract, which had these provisions in May of 2023,
right?
It seems like you were supposed to close in September, and after the time of Essence letter was sent in September, your architect went in and visited, right, on September 20th.
On September 20th.
Right.
And
waited a long time, and then they said time of the essence was October 16th.
Well, we agreed to October 16th as a mutual time of the essence deadline. The architect states, as your honors have stated, it is our assessment that these 7 windows are in poor condition and have not been maintained for proper operation. The definition that the parties agreed to is that it has to be operational and adequately perform their intended function. Our basic position in this case is that windows being in proper working order is a condition precedent to passing of to our obligation to accept title.
Thank you. Thank you.
Thank you.
Endurance American versus StoneX Commodity.
May it please the court, my purpose here is to introduce my co-counsel, Mr. Adam McCabe, who's duly licensed in Illinois and has been admitted pro hoc for this case.
Good afternoon, Your Honors. May it please the court, Adam McCabe on behalf of the plaintiffs' appellants in this case, who are insurance companies. We're here today based on a decision in order from Judge Frank, which made 2 separate determinations. The first, the court determined that the defendant had made a sufficient showing of an actual physical loss of soybeans. And the second was that the court determined that the defendant had made a determination as to the date of loss of its claim.
In dealing with the physical loss of soybeans, how does the bankruptcy action that is in this case, where the defendant would no longer technically have control over it because it's now in bankruptcy, does that matter at all?
So I believe the bankruptcy has little to do with the actual loss that has been asserted by StoneX in this case. And that loss was a third-party theft misconduct. It's in their submission of the claim to the insurance companies, it's in their counterclaim, it's in their briefing on summary judgment, and it's even in their response to this appeal. They assert that there was a third-party theft by Express Grain Terminals. They tie the bankruptcy.
Up the misappropriation exclusion now? Is that why you're raising the alleged theft?
Well, we do assert that there are factual issues as to that exclusion.
I understand you have an argument about the misappropriation exclusion, but what does that have to do with the issue about whether or not there was a physical loss or not? Whether or not it was from theft or for whatever reason, it seems pretty clear that at some point they did have soybeans and then they didn't have soybeans. So what does how it occurred affect whether or not there was a loss versus as opposed to the misappropriation exclusion?
Well, with respect, we would disagree that there has been a demonstration of actual soybeans in existence in the quantities.
What does the theft have to do with whether or not they had the soybeans?
The misappropriation exclusion has nothing to do with the physical loss issue. That's a completely separate
How
issue.
does your argument about the theft have to do with whether or not there was a physical loss?
Because
Does that tie in?
in order for there to be a theft, there has to be a physical existence of soybeans.
So you're saying
as reflected.
you had to prove that they existed in order to prove that they no longer exist, and that to show a loss. But didn't
Correct.
Stonex show in the record that those soybeans were, in fact, in existence by submitting reports dated April of 2020 and March and October that showed that they had enough soybeans to cover however millions of bushels of soybeans Stonex thought was being stored there?
Yes, for the support that they offered 3 inspection reports conducted at 3 separate dates to cover 8 warehouse receipts issued on 7 distinct dates, some of which were years in advance of those inspection reports. That's not the purpose of Clause 15, which is what needed to be satisfied. And that's really what the crux of the argument here is that did those inspection reports satisfy Clause 15? They have aggregated in their inspection report a number of different warehouse receipts covering different sites.
All in Mississippi and all under the same license in Mississippi, correct?
Correct, but those are 3 separate sites that are each identified in the policy separately.
They also had the power.
Go ahead. I think we're going to ask the same question.
Okay, they had the power to direct that soybeans be taken from one of the facilities and given to another to satisfy a warehouse receipt.
That is a legal argument having to do with the agreement between Stonex and EGT. We're talking here about an insurance policy and what the insurance policy required. The insurance policy required that a specific warehouse receipt in the singular, that the requirements under that warehouse receipt, which included the quantity, included the location, included the commingled nature, yet we have inspection reports that state on their face, we can't tell you if these are actually your soybeans.
How do
because
we
don't
know? How do we know what storage facility means in the insurance policy, since it's not a defined term, that it doesn't mean more than one location?
That I believe the policy itself has a schedule of facilities, and that schedule has 3 separate facilities for each of these separate warehouses in Mississippi. But beyond that,
But why
we're
couldn't
talking about an
storage
ambiguous
facility
term there.
mean all of the storage facilities when it's stated in the insurance policy?
It's stated in the singular, storage facility. And again, we have 3 separate locations in 3 separate towns, and each of them are separately listed in the policy schedule of locations. So we believe it's clear that a storage facility refers to an individually scheduled location in a separate town from the other locations.
I don't understand. It seems to me that if you want to read the whole contract together and you list 3 separate facilities and the contract talks about a facility, then the obvious way to read that is as a collective noun referring to all 3 of the ones enumerated.
Because each of the warehouse receipts on their own, which are to be viewed individually, they each identify only a single location. They don't aggregate as the inspection reports do. And if I may, really quickly, I'd like to discuss the date of loss issue. We have a loss, again, that has been argued that was a theft. The Stonex is trying to connect that to a separate event, which is the bankruptcy restraint. Those are 2 different events, and so they have to have 2 different dates of loss. We're not talking about the bankruptcy court stealing or engaging in misconduct in restraining those goods. We have a theft that is conducted or that it was engaged in by a separate third party, and that has a specific date of loss separate from the bankruptcy action.
Thank you.
Thank you.
May it please the court, Josh Blasvaren for respondent Stonex. First, I'd like to point out that this argument about that we shouldn't be able to aggregate is a new argument that was not presented to Justice Frank. In the summary judgment briefing below, the insurers argued that the warehouse receipt, that the inspection needed to demonstrate that there was enough, that the quantity of soybeans was large enough to cover everybody's warehouse receipts, all the creditors, and Justice Frank applied the plain text of Clause 15 and rejected that argument. Now, on appeal, for the very first time in this case, they're making this other argument that we can't aggregate. And I sensed some skepticism on the bench as to their new interpretation. And I think beyond the fact that it took them years to come to this apparently reasonable interpretation, I think
What is wrong with their interpretation, though, that storage facility means a storage facility as opposed to multiple storage facilities?
Well, first of all, as I just mentioned, I think if this was so reasonable, it should have dawned on them when we fully briefed and argued this below.
Assuming
I
we're
think
going to
they're-
address it, let's
I-
hear your argument.
Your Honor, I understand. And I think they're pinning this all on the singular use of warehouse. I think any reasonable business person, including StoneX and including the underwriter who knows how to write policies covering storage and cargo, would know that in this business, this is how they operate. This is how they're legally operating, and this is how they're factually operating. They're moving things around. They're entitled to do that. StoneX is entitled to demand that soybeans be transferred to whichever location is named on a warehouse receipt.
Also, are you favored, or is your client favored by rules of interpretation for an all-risk policy?
Absolutely, Your Honor. And not just all risk, but just insurance policies in general, from Westview Associates and countless other decisions by this court and the Court of Appeals. Any ambiguities must be resolved in favor of the insured and against the insurer that wrote the policy. But I don't want to lose this. Even accepting that the appellants did not waive this argument, and even accepting their interpretation, they still can't win, because the March 8th, 2021 warehouse receipt completely satisfies their reading of Clause 15. On March 8th, 2021, an inspector went to the 3 facilities and found there that these facilities had 5.6 million bushels of soybeans. All of the warehouse receipts that had been issued to StoneX by that point totaled 5.3 million. And what's more, he said, I physically and visually inspected and measured sufficient number 2 yellow soybeans to cover all stated company-owed obligations at all locations. That means that he looked at the 3 locations and said, this meets every requirement. And from that point forward, it's not as if StoneX kept buying more. So we proved the existence of the soybeans at this period of time. What actually happened over the course of 2021 is that StoneX sold some of these soybeans, so they had less going forward. But as of March 8th, 2021, for all the warehouse receipts.
Do you want to address the date of loss issue and whether the bankruptcy was
Of course, Your Honor. Whenever the thefts occurred, and there were thefts, they were remedied by the date of the bankruptcy. As of the date of the bankruptcy, StoneX had warehouse receipts totaling 2.78 million bushels of soybeans, and EGT had in its facility more than that. There was no loss. So, Your Honor, if I could give you sort of a silly hypothetical, but if a bank is robbed, and 2 days later the police catch the robber and return the money to the bank, that's not a cognizable loss. And also, if on December 31st a bank is robbed of $1,000, and then in January the police apprehend the suspect and return half the money to the bank, how can you say the loss occurred in January? The loss occurred when they were robbed. Now, the fact there were mitigation efforts, just like StoneX continued to try to mitigate its loss to the benefit of the insurers after the date of loss, doesn't mean that the date of loss was not when they were dispossessed of the property.
This may be a silly question, but if there were enough soybeans for all the receipts, why wasn't there a full recovery in the bankruptcy? Was it because they weren't sold for enough?
Sure. Well, that may be part of it, Your Honor, but first of all, there were administrative expenses, so at least $1 million went out the door to that. Also, there were competing claims. Now, StoneX had superior interest in the soybeans, but there were competing claims, and this was a settlement. And this isn't all on the record, Your Honor, but settlement, you can take judicial notice of why parties enter into settlements to resolve outstanding claims and get their property back.
But it wasn't because there weren't enough soybeans. The settlement wasn't based on the fact that there were not enough soybeans to cover the warehouse receipts.
Well, there weren't enough soybeans to cover everyone's warehouse receipts, but there were enough soybeans to cover StoneX's
There were
warehouse
other people other than your company that had soybeans at this facility?
Yes, with varying degrees of.
I guess that's what I'm trying to understand, were there enough soybeans to cover everybody's warehouse receipts, or there were enough to cover your?
No, there weren't, but as Justice Frank.
Okay, I was
No,
just
yes.
confused by the way you put it before. Okay.
If I could just briefly address well, my time is up, so I can't. Thank you, Your Honor.
Thank you.
Quickly, Your Honors, to touch on a few points. regarding the date of loss, counsel just stated there were enough soybeans, so there was no loss until there was no remedy. If that's the case, then the bankruptcy restraint was the loss. And if that's the case, which I don't think counsel wants to suggest, because they've suggested this entire time it was a theft, but if the bankruptcy restraint was the loss, then that is an excluded peril under the FCNS clause, exclusion of the policy. But this entire time, they've taken the position that the theft was the loss. And that's discussed in our reply brief. Really quickly, with regard to this issue of single facility versus multiple facilities, the inspection reports aggregate the facilities. The warehouse report lists a single, or the warehouse receipt lists a single facility. The inspection reports are the ones that aggregate, and nowhere in the March 8th inspection report is it discussed by the inspector that he satisfactorily counted at each individual. He says all facilities, so he's aggregating himself. And finally, there is no waiver here because this is an issue of contract interpretation with which this court is allowed to take up on the sufficiency of the inspection reports, which was at the heart of our entire argument. Thank you.
Upfront Megattainment.
You ready?
What?
May it please the court, Cynthia Arado, and I'm here for the appellant, the artist professionally known as Akon. The appellees are not entitled to a recovery of their attorney's fees because the language of the settlement agreement fails to make unmistakably clear, as the Court of Appeals requires in Hooper and Mount Vernon City School District, that fees were awardable outside of the narrow circumstance of a streamlined confession of judgment procedure. Here, the language of the settlement agreement and the confession of judgment make clear that appellees may recover only the reasonable fees incurred to enforce that judgment. The appellees admit in their brief that they did not seek to enforce any confession of judgment, but they're only seeking fees because they were trying to enforce a payment obligation.
Well, they basically make the argument that the confession of judgment was incorporated by reference into the settlement agreement, and therefore somehow the attorney's fee provision was also enforceable in a plenary action.
The settlement agreement does refer to the confession, but the settlement agreement repeats and actually makes even clearer that a right to attorney's fees is limited to enforcing the judgment. The judgment itself says you can get fees incurred in enforcing the judgment. The settlement agreement says you can get fees actually incurred to enforce the judgment. So the settlement agreement does not provide any rights that go beyond the language of the confession of judgment itself. The Mid-Valley case, which appellees cite, is right on point there. A debtor signed a settlement agreement and a confession of judgment and defaulted, and the plaintiff brought a plenary action because the confession of judgment by the time of the action was invalid, and the debtor tried to thwart the action on the grounds that the notice provisions of the confession had not been honored, and the court ruled that the notice provisions and the terms of the confession had no application in a plenary action, and therefore there was no basis to impact the action, and the same is true here. There was no confession at issue, and therefore you cannot bring, and the confession was invalid by the time this action commenced, so therefore they can't rely on the attorney's fee provision in the confession to obtain their fees. The fact that the confession was presented to the court as an exhibit to an attachment motion doesn't change the analysis because, again, there was no steps taken to enforce the confession of judgment. Thank you. Thank you.
Good afternoon, Alexander Sakin for the plaintiff appellee.
Upfront Megatainment, Inc. Your Honors, I think it is worthwhile to focus on provision 2C of the settlement agreement at issue in this case. It speaks of, it entitles my client to the recovery of reasonable attorney's fees actually incurred to enforce the judgment. It is notable what it does not say. It does not say successfully enforce the judgment. It does not say enforce the valid or
If it didn't
enforceable judgment.
If it didn't enforce the confession of judgment, what fees did it incur in enforcing the judgment? It brought an action on the
Right.
settlement agreement, but it never sought to enforce the confession of judgment.
Well, Your
So
Honor-
why then, how could it have occurred any attorney's fees in seeking to enforce the confession of judgment?
Your Honor, I think as the lower court said, that this provision entitles them to attorney's fees regardless of the method chosen. So the
But
point,
where in the agreement does it say that? The agreement seems pretty clear that it can recover attorney's fees in connection with enforcing the confession of judgment, but it doesn't say anything about whether collect attorney's fees more generally. And since courts generally narrowly construe agreements for attorney's fees, how would they be recovered in this case?
well, it is incorporated in the agreement, this provision, and I think that one way to look at it, in the way that I present it, is it's in some ways a unsuccessful attempt to enforce the judgment. If, let's say, we had
How could it be when they didn't try to enforce, I mean, it was a very specific agreement. It said in connection with the enforcement of the confession of judgment, and that choice was made not to proceed that way.
They made the choice to attach the judgment to the complaint, to the motion for attachment. It was whether the enforcement was successful or not is, in our view, beside the point.
You're saying by attaching the confession to the complaint, that was enough to bring in that provision that you can get fees in connection with the enforcement of the judgment?
Yes, and the fact that this provision is incorporated in the body of the agreement shows an intention by the parties to provide for the recovery of attorney's fees in case Mr. Tiam failed to satisfy his obligations. I mean, the example that I provide.
If that was the intention, why wouldn't it have had a freestanding provision about attorney's fees, not one buried in a paragraph about a confession of judgment?
Well, Your Honor,
We tend to interpret attorney's fees provisions narrowly because of the American rule. So why would we interpret it broadly in this case?
Because there was no reason to include it in the body. They could have had it simply in the confession of judgment, but they had it in the body. And as the point that I make in my papers shows, I mean, if let's say there was a completely valid and enforceable judgment, they went to the wrong court, that effort would still be, I think, compensable. Thank you.
Thank you.
Thank you.
If the court has no questions for me, I'll rest on my opening remarks.
Thank you.
Thank you.
And our last case of the day, Rivera versus New York City Department of Transportation.
Good afternoon, Your Honors. May it please the court, Jennifer Lerner on behalf of appellants. This court should reverse. This is a clear case where Supreme Court misconstrued the legal standard and abused its discretion by allowing Rivera's late notice of claim where none of the three factors were satisfied. Starting with actual knowledge of the essential facts of the claim, which the Court of Appeals in its decision in Jamie just last year reiterated that the courts are to place great weight on this factor, and that the party seeking leave has the burden to establish through non-speculative evidence. Here, Rivera alleges that he tripped and fell, stepping up onto a curb from a street that was being resurfaced and repaved. But there's no
Counsel,
dispute.
Haven't we held, or hasn't the Court of Appeals held, that knowledge is not imputed just because some other branch of the city, and HHC is not even a branch of the city, just because they have some knowledge of it, it doesn't impute knowledge to the city. How do you get around that?
Well, so that's correct. That there.
Oh, I'm sorry. Pardon me. It's late in the day.
Yeah.
I apologize.
So I don't get around that.
You rely on
She
that.
can't get around that. So just to briefly address that, that was raised on reply, that which is a new argument that was raised on appeal and not below. But yeah, HHC is a separate entity, has been held to be so by the Court of Appeals specifically for notice of claim. So there is no way to impute knowledge to the city based on whatever those records may show, which was not before the court. And to bring that around back to actual knowledge and prejudice, the Rivera speculated that there were records in the city's possession, but made no attempt to get those records. They're not before the court, and I don't think the Court of Appeals was breaking new ground in Jamie, but they made abundantly clear that conclusory allegations about records in the city's possession is not enough to establish actual knowledge. And here, in this case in particular, there's no reason to believe any records, any construction records, would make any mention of a slip and fall accident from a passing pedestrian. As to prejudice, and I'm going to point to the record, it's at page 20, it's paragraph 12 of the attorney affirmation. The whole of Rivera's attempt to meet his burden on this factor is the statement that defendants will not be prejudiced by having to defend the present action on the merits. There's no further explication, there's nothing further. And we would submit that as a matter of law. That statement is insufficient for Rivera to meet his initial burden. Newcomb is clear that a would-be plaintiff must come forward with some evidence or plausible argument of no substantial prejudice, and he did not do so here. And the court's error was in basically making his own speculation about what prejudice might or might not exist. We would submit that the court was wrong about the records, but in any event, the first step should have been assessing whether Rivera had met his initial burden in order to shift that burden to the city, which it never did. Last, on reasonable excuse, which was the only factor where Rivera made any showing at all. The records he provided do not substantiate his entire year-long delay.
We have found that medical excuses can be reasonable excuses.
Sure. And here, this was a broken ankle. This was not a case where he was completely incapacitated. And in any event, he only submitted records. So the alleged accident was in May 2022. He submitted medical records showing that he had surgery the next month in June, and then had follow-up physical therapy and appointments thereafter. The records end in January 2023, and he did not bring this case and submit a claim until August.
Thank you.
So therefore, it's not substantiated. Thank you.
Good afternoon, Your Honors. Dora Lasalle for the plaintiff respondent. The Supreme Court did not abuse its discretion in determining that.
Ms. Lasalle, can we talk about reasonable excuse? Because
yes, of course.
I gather the plaintiff did travel to and from Ohio at some point. Ohio. And unless I'm mistaken, but wouldn't that imply that he'd also be able to cross town to find an attorney?
Your Honor, I'm not aware of travels to Ohio.
I think there was something in the record, but there was something about that he got on a plane and traveled somewhere. But even putting aside, what about counsel's argument that with a substantial period of time between when he had the surgery and the operation and then when this claim was actually commenced, which couldn't really be explained by the medical records that were submitted?
Well, Your Honor, I will, freely admit that the time constraints that were attendant to my office at the time that the plaintiff consulted with my office it was a short period of time. We did what we could in the amount of time that we had to bring forth this motion.
But there were many months between the time that could have been brought, and this was interesting because it was actually like the last day.
It was,
under the statute of limitations. There was no more time.
Right. Admittedly, the timing was left much to be desired.
So what's your reasonable excuse?
Nevertheless, at the time, those were the medical records that were available to the plaintiff and to my office. Those were not exhaustive. Separate and apart from that, Mr. Rivera did submit his own affidavit in which he details the extent of his recuperation and his recovery, which at the time of his submission, when the application was made, he was still suffering from and recuperating from.
But we've had cases where people are hit by a train and they really are incapacitated in a major way. This was not that type of case. He didn't suffer those type of injuries. So how, based on the injuries he did suffer, does that explain why there was a year and 90 days delay in commencing the action.
In all honesty, I mean, Your Honor, as Mr. Rivera details in his affidavit, he was in excruciating pain, supplemented by medications. I can't speak to other, potential plaintiffs who've had perhaps assistance of other individuals to help them bring a claim. At the time that he actually consulted with my office, the statute of limitations was looming. Separate and apart from that, though, however, we would submit that his injuries and his pain, which is completely subjective to him, is a reasonable excuse for the delay in bringing forth the notice of claim.
Okay, so what about the prejudice then? Since
Your Honor,
you have the burden on that. How did you show this, the Department of Transportation was not prejudiced?
Well, with respect to the issue of prejudice, we simply argued that there can be no prejudice in proceeding on the merits. The singular purpose of the notice of claim is to afford the city an opportunity to just preliminarily investigate the claim and determine whether or not it's a claim that they want to settle early or they want to proceed with on the merits. It's not whether or not they can mount a defense at trial and garner all of their evidence.
There are situations where there may be witnesses that may not be available at a certain point, or they may not be able to find. And those are the types of prejudice that I think the court looks for. And here, it was such a general statement.
Well, there are, but none of that is alleged. The city certainly doesn't allege that there are
You
any
have the
documents that are
burden under the
missing,
current
that there are
state.
any witnesses. I'm sorry.
You have the burden under the current state of the law to show that the Department of Transportation was not prejudiced. So your client has the burden, so how did you satisfy that?
Well, the burden is satisfied simply by saying you only have to show that there's a plausible argument for there not being prejudice. And again, our plausible argument is that there can't be any prejudice because there hasn't been any showing that there's anything that's missing or that they can't otherwise secure. There's been no showing whatsoever, no witnesses that are unable to be located or identified, no documents that no longer exist or can't be found. The photographs indicate exactly that at the time of the fall, there was ongoing construction at the location.
Thank you.
Thank you.
So just briefly on the prejudice point that was just being discussed, I submit that the argument Rivera is making is circular here. I mean, it's saying that they're making a showing of no prejudice because the city didn't come forward to show prejudice, and that's not the way the burden shifting standard is supposed to work under Newcomb. And here, I mean, the purpose of the notice of claim, this is reiterated in Jamie and other cases, is to afford the municipality the opportunity to investigate and preserve evidence. So there's a presumption that there is some prejudice from delay. That's why the would-be plaintiff has to come forward to show there were not, and then that's when the burden shifted. So because Rivera did not do that, the burden did not shift here. There was nothing, counsel referred to pictures showing something. That was only submitted on reply. In the initial application, it was not even clearly alleged that the work was being done by DOT or by the city, and it was in response that they submitted a picture. So we definitely submit that there was no burden shifted here. And as to reasonable excuse, what was submitted, even in the affidavit, just doesn't substantiate the full year-long delay.
Thank you.
Thank you.
I know.